This conference is now being recorded.
Good afternoon. Welcome to the New York State ASBO webinar, Policy and Procedure Case Law. My name is Matthew Darius. I'm your moderator for today. Our special guest speaker for this topic is Joe Shields from the firm of Ferrara, Fiorenza, Larison, Barrett, and Reitz. And without further ado, Joe, it's all you.
Okay, thanks, Matt. Good afternoon, everybody. My name is Joe Shields. I'm a partner with the Ferrara Law Firm. We have a small group. I don't know if you see the number of participants, but the good news is there's not too many. So feel free to ask questions as I go through the materials today, and I think the way you do that is...
yeah, I forgot that little part. Sorry. You can either ask a question by using the chat pane on the right-hand side of your screen, or you can hit 7# on your phone. That'll notify me you have a question. Everyone is muted by default, but hitting that 7# tells me that you want to talk to Joe. I'll then break in and unmute you, and then you two can have a chat. Okay, great.
So I'll get started. The topic is relatively broad, as you'll see, but what the areas that I'm going to cover this afternoon, and I'll field other questions to the best of my abilities that are not related to this, or tangential if you want to go ahead and ask them. But basically, the overview of the presentation that I've prepared would be to talk about, in the first instance, procurement do's and don'ts. What's the right way to put bids out for capital projects, for any items that school business officials need to procure. In our practice, I've come across, various times where some business officials have just followed what their predecessor may have done, and they haven't had a refresher on the procurement do's and don'ts, and so I thought it might be useful for folks to hear some of that information. The second issue is public works and prevailing wages in New York. I've noticed that the Department of Labor has stepped up its enforcement actions and been a little more aggressive with some of our clients in auditing them and finding out if they are following the right procedures with public works and prevailing wage. So I'll go through those topics and some practice tips for you folks in both managing your either a capital construction project or just service contracts or repair contracts where you're hiring outside contractors or subcontractors. The next topic is the open meetings law. And to just remind folks, everything school districts do is subject to the open meetings law. There is the exception for the executive sessions. I'll talk about that briefly for you. My thought for a school business official, your lens on this topic would be you're oftentimes the folks that are asked to prepare information for school board meetings and have documents ready, and whether you're going to be in the room with them board or not at that time, but to go through some of that. And lastly, with respect to the open meetings law, is that new disclosure requirement where school boards are now, since February, obligated to make documents that will be discussed at the board meetings readily available to the public to the extent practicable. So that's an overview of where we're going to go. And as I said before, feel free to ask questions as we're going along. Okay. So starting with the procurement do's and don'ts. The overview for procurement do's and don'ts is that, as I'm sure you're all aware, there are basic bidding requirements. There are exceptions to those, which I'll cover. So I'm going to go over the basic bidding requirements, cover exceptions to those, and then talk about some cooperative purchasing arrangements or ways to do that. Everybody's in the mode of trying to save money and be more efficient. Talk about Article 5G agreements and ways that school districts may be able to collaborate with either their towns or villages or neighboring school districts. Okay, basic bidding requirements. As I'm sure you're aware or should be aware, the public works contracts, which is any contract that is going to be for construction in excess of $35,000 must be competitively bid under the general municipal law. Now, the basic bidding laws have been in effect since as early as 1853 in New York State. In 1953, Article 5A of the General Municipal Law was enacted to provide a comprehensive general competitive bidding statute applicable to all political subdivisions, of which a school falls under the definition of a political subdivision. So if you're going to let a construction contract in excess of $35,000 or a purchase contract in excess of $20,000, then you must competitively bid that. And what that means is that you must advertise the bidding and wait in your paper or newspapers of designation for your school district, and wait the 5 days after the advertisement for the public bid opening. An important point is you cannot avoid the bidding requirements by signing a series of contracts to say, okay, well, we need $24,000 worth of computers. Let's go sign 3 purchase orders for $8,000 each, and then I'm not going to need to competitively bid it. Obviously, you can't do that. The comptroller has taken that position, and you would be, written up as a result of that. The basic bidding requirements, information provided in a bid request or quotation should cover each of these things. This is geared towards if you're going to put a bid out by yourself. Now, in the capital projects, you will have the assistance of the architect or construction manager who's going to put together the bid package for you. But if you're going to put out a bid for a scoreboard on your own, or procuring certain items, I'm sure your district has a general conditions of contract that you would use to attach to your own bid specification. But what this is designed to tell you is, you need to think about and make it clear what items and quantity you're desiring, the statement, how the pricing is to be worked. And then if you're going to use a specific manufacturer's catalog number or a specific product, you can do that, but make sure that you always include the language that allows for an equivalent, because there may be some product that is equal in nature to the one that you're specifying. An example would be a Xerox copier. If it's the same, if Icon or Toshiba could come out and meet the same requirements, then you would be obligated to review those specifications and perhaps award a contract to them if they were the lowest responsible bidder. Okay, so as I mentioned a moment ago, when you're going to do basic bidding requirements, you're obligated to require advertising for sealed bids, which means that the bidders must submit a sealed envelope, typically to your office if you're the one that's running the bid specification. One practice tip is please make certain if you're putting out a bid not just to have the school main address. I like to designate or make sure that clients designate a specific room within the building, because if it's that all-important 2 o'clock deadline for the bid to be delivered, any bid that's not delivered prior to the 2 o'clock deadline must be rejected as untimely, right? But if you've just used the general school address, you don't know that you run a greater chance of having someone argue, well, it was in the nurse's office, or it was in the main office or the secretary's office. So if you specify that it must be delivered to your specific room number, that allows you to maybe avoid that misstep and have to just deal with a discovered bid. Once you advertise in your newspaper that's been designated, you must wait at least 5 days between. Now, you can wait more than 5 days. You could have 10 days in there if that's what you want to do. But the minimum is 5 days notice. And the reason I mention that, you know, and I'm emphasizing the 5 days, is sometimes folks try to really avoid having to go bid a document or a remedial work in a construction project or something. It really, to me, is an exercise that's beneficial to complete. I mean, obviously, legally you have to do it, but rather than try to circumvent it and try to save time, there's really not much time you're saving. It's only this 5-day time period that you have to do. And by forcing yourself to go through and compile the specifications in the details, you're ensuring that you're at least enhancing your chance that you're going to get a better result rather than just trying to go secure quotes from 2 different vendors. So now, with respect to construction projects, there's a thing called the Wicks Law. The Wicks Law requires school districts to bid 4 separate contracts as a minimum when you're doing a capital construction project, which now exceeds $500,000. Prior to 2008, it was $50,000 was the limit for the threshold. But now in upstate New York, it's $500,000. If anybody is downstate, Long Island, in New York City, the threshold is higher down there. It's like $1.5 million, I think, on Long Island and $3 million in the city of New York. I'm not sure if anyone's from there down on this call. But the important thing is if you have a project that is going to exceed $500,000, when you go to do the bid documents, the architect and the construction manager must set up 4 separate prime contractors, 1 for the general construction, 1 for the plumber, 1 for the electrician, and 1 for the mechanical contractor. And that's the minimum number that you should do. A practice tip that I like to give to my clients is that's really the number of prime contracts that you should do. A lot of times school boards or architects or construction managers try to go out with a bid package with 10 prime contracts or 7 or 8 prime contracts. The reason I discourage people from doing that is school districts, when they have a capital construction project, have a non-delegable duty to coordinate and manage all of the prime contracts. So my rationale for using the minimum 4 number is if you only have to manage 4 prime contracts, if you only let 4 prime contracts. If you let out 7 prime contractors, then you're duty-bound to manage and coordinate all 7 of those contracts. Now, if you have competent construction management firm or you have your finger on the pulse, you can go ahead and do that. But in my opinion, you're increasing the likelihood of having potential problems during your capital construction project. One more point on this Wicks Law and the $500,000. If you have a project that is under $500,000, I know a lot of people are doing small projects now that, you know, you actually may do something that is under $500,000. You could go out with a single prime contract, and you would not need to follow the Wicks Law. Well, you wouldn't need to have 4 primes, but you do. There are specific requirements on how the bidding must be done, and that is that the prime contract, if you're going out with 1 prime, has to solicit subcontracts and submit them in sealed envelopes, and there's a detailed procedure in the general municipal law that you and your architect should follow if you're going to do a project under $500,000. Don't simply just say, oh, good, we can just go out with a single prime contract and not pay attention to those details, or you'll end up with a problem. Big thing about the Wicks Law and the bidding laws, from my perspective, is that the bidding laws and the general municipal law, you know, is designed to protect you as school districts and other municipalities. They are not designed to protect the contractors. And so many times I've had clients tell me, well, we had to take the lowest bidder. He was the lowest bidder, so we had to take him. And they think that they don't have any discretion as to who to award a contract to, and that's just simply not the case. The law says that you must award to the lowest responsible bidder, and there is due diligence that you're allowed to do before awarding a construction contract to a contractor. The contractors have to submit a bidder qualification statement, and the threshold question is, did they tell you the truth? Because if they didn't and they lied to you, there's case law in New York that says you can reject them on that basis alone. So you could, disqualify the low bidder in and of its face if you give documentary proof or some type of proof to see that the contractor was the bad apple or, didn't tell you the truth there. The other thing is, even if they haven't misled you or not told the truth, you don't always have to just award to the low bidder. If that contractor has, when you compare his or its contractor qualification statement to the second low bidder, you can do a side-by-side comparison and do due diligence on the bottom, your lowest two contractors, the lowest price for the lowest two, or even sometimes the lowest three, to find out, by talking to references and by checking to say, has this contractor ever filed claims? Has this contractor finished his jobs on time? Have there been litigation? Does he ever get cited by the Department of Labor? Was the contractor ever on the debar list? Because any of those things, you would be able to say, okay, no, you're not the right guy or right entity. I'm going to move to the next bidder. And the reason I emphasize this is in the projects, if you get the wrong contractor, it can make one contractor can make the entire project more difficult for you to manage or to complete on time. And if you spend a little bit of time up front by not awarding to that person, you can avoid, big construction litigation down the road. The final thought on this topic is that if a contractor wants to challenge the board's determination not to award it, a contract is the lowest responsible bidder, the contractor does not get awarded the contract. All the contractor would get would be a court order saying that you need to go back and rebid the contract. The board's determination that he wasn't or it wasn't a responsible bidder must be set aside. And all you would lose is time. I recognize that sometimes time is critical when you're dealing with these projects, but again, haste makes waste, and by slowing it down, you may really save yourself headaches and expenses on the back end of a project. Exceptions to bidding, the bidding laws. There are several of them, and I'll go through each of them. The first is an emergency, an accident or an unforeseen occurrence where there's a danger to health, safety, or property of the school district, and it requires immediate action. This is also known as an ordinary contingent expense or an emergency project, where you could talk to your project manager at the state education department and say, we need to hire a company immediately. We had a roof blow off in a windstorm or an ice storm. We had a roof collapse or a flood damage. We need to clean the property. We don't have time to put a bid package together and to go out and wait, even 5 days to stop, because by then, a lot more damage would occur to the school district property. That's all well and good, and the way you do that is you would have the Board of Education adopt an ordinary contingent expense resolution, work with the architect and where the source of the funds would come from, and there's some detailed procedures that you got to make sure you follow. But then you could go ahead and just award a contract to a contractor to complete the work. The key with the emergency projects, from my perspective, is that what that allows you to do is to, if in the instance of a flood, to have a company come in and stop the source of water from coming in, or to patch the roof, intermittently if a roof blew off, to protect and seal the building from the elements, and maybe even the initial disaster removal, where you pick up the debris and get the water out of the building to avoid mold and that type of situation. What that doesn't authorize you to do, though, and what some folks have done in the past, is then go ahead and try to do an entire capital project, a new renovation project, based on that. And so, that's the caveat. Just be careful that you can do an emergency project to clean up or stop the problem, but that doesn't let you go and completely put in a new gymnasium if that's the roof that blew off. You could stop the water from coming in, do the initial cleanup. Then if you have to replace the gym floor, you're probably going to be going through the insurance company anyway or some contractor and dealing with the particular instance. But that's the key with the emergencies. With another exception to the bidding laws would be if there's only a sole source of for a specific product or for a service that you would normally bid, but no one else does it, then you could go ahead and not bid that work, but you can go ahead and do a sole source resolution. The Board of Education actually adopts that. It's important that you have to have the proof, though, behind the resolution to show that there really is only one entity that provides this service, or some other instances where people have done sole source is if you have computer programs that run your mechanical system or proprietary software where there's an interface, you can have the architect help you in saying, look, we need to sole source this topic. But then the architect has to, or the engineer has to really show that some other system simply couldn't be compatible with what you have as an existing system. Further exceptions to the bidding laws are professional services, legal services, medical services, property appraisals, or insurance. All of these are, you're not required to publicly bid these. Typically, with the legal services or these professional services, districts, and the comptroller has been saying lately that districts should issue requests for proposals for these services. It's not a general municipal law requirement that you do that, but the caveat is to check your own school policy or procedure. If your school procurement policy requires you to issue RFPs, then you should, in fact, comply, obviously, with your own policy, even though the general municipal law doesn't require it. And the comptroller's office has been writing districts up for not issuing RFPs for some of these services, for the legal or the medical professionals or the appraisals. Some alternative processes that also, don't require you to go out and competitively bid are these, when the point here is, although you may not need to be competitively bid the work, the key is follow your own procurement policy. And you want to be, obviously, as the business official, you want to be able to show to both your board that, and especially in these tough fiscal times, that you are getting the best price for, and the best product that's possible. So although you may not be legally obligated to do that, you want to get 3 quotes, or you want to try to, get the best price possible. If you're going to do separate RFPs or separate bid documents, the one caveat that we would have would be to have the RFP documents and your general conditions for your procurement documents reviewed by your school attorney. If some folks come into new positions and they use the same form that the predecessor used just automatically, I've come across districts where they were using the procurement documents from the 70s, and times have changed and some of the requirements have changed. So just, have a refresh look to make sure that the general conditions that are set forth in your procurement documents have been looked at by your school attorney and that they're up to speed. That's the point with this. With respect to cooperative purchasing by 2 or more school districts, school districts are permitted by Article 5G to go ahead and enter into cooperative purchasing. Now, what this means is that anything that a school district could do, any contract a school district could enter into by itself, if you can demonstrate that, or if you can learn that you might make a savings by buying them in more quantities or larger quantities, you may consider partnering with a neighboring school district to try to procure, or the BOCES, to procure these top products on a bulk basis and therefore save some revenue. A 5G agreement is very easy to draw. The bottom line is that when you're entering into one of these arrangements, the key is to make sure that it's approved by both boards or both districts, that the cost of the operation would be prorated. So if you're going to do these joint, fuel islands or a sewer project, I've done them for bridge work or fuel pumps or some type of construction project, or even just some procurement piece, make sure that you are having the agreement drawn where it's approved by both boards of education. If there are costs associated, that the costs are split on some prorated basis between each entity. That joint operations must be coordinated by the 2 districts or 1 agent, and that each participant should appoint a representative to coordinate with the others so that you have a designated decision maker on your district's behalf, and that you're clearly communicating to the other side the quality standards that you need, the quantities that each district needs, etc. So drawing a simple 5G agreement would allow you sometimes to enter into these cooperative savings purchasing agreements and save some money. There we go. All right. Now, the next topic that I'm going to talk about is the prevailing wages in New York State. Now, we're done with talking about the bidding and the laws and the requirements. The second topic that I wanted to focus on today was prevailing wage and the labor law in New York State, the Department of Labor, and some of its recent enforcement actions against school districts that we've seen. So under the New York State labor law, contractors and subcontractors of school district must be paid prevailing rate of wage and supplements to all workers under a public work contract. This includes your construction, your alterations, and some repair contracts. It even covers your current, if you have a contract for someone for trash removal, there are certain service contracts that under the Department of Labor website you'll see you must pay prevailing wage, and that's something that a lot of districts aren't not aware about. So the contractors are the ones that are, the employers are the ones that are obligated to pay the prevailing wage. The district isn't. You're entering into a contract with the contractor. But what the district is obligated to do is to ensure that the contractor is doing that is to require the contractors to submit certified payroll statements where they are giving a sworn statement indicating that they are in fact paying their workers under the public work contract a prevailing wage. I have a lot of projects right now where school districts are being gifted money or insurance proceeds where the district has won an award or the insurance company is going to pay on a claim, and people ask, is there a way we could not do prevailing wage when that's the case? When we're being gifted money, the source of the funds is coming through an insurance company or a private donor, could we avoid it? And the answer I'll give you the answer first, and then we'll go through some of the details, is no, you can't avoid it. Since you folks work for school districts, public works contract is a contract that involves a public agency, and the first element is why a lot of folks think that they could work around it if their contract was with the insurance company, where the insurance company is going to pay the contractor directly, because they say, well, the public agency is not a party to the contract. But the second prong of this slide, with the Hartnett case, is what is the catch-all, and that provides that any contract that concerns a public works project must be paid prevailing wage. So even if the source of funds is some private donor or insurance recovery, since the work being done is for the benefit of a school district or a public body, then you are in fact obligated to pay the prevailing, or the contractor is obligated to pay the prevailing wage. Now, contracts that concern a public work project include the maintenance and repair of public work. So even when you've got projects for maintenance and repair, they are obligated to be paid the prevailing wage. And again, that's something that I think a lot of districts are not aware of. And so if you ever have a question, the main practice tip for you today is, if you have a question as to whether or not a contract that you're letting out on your district's behalf is a public work contract, you can ask the Bureau of Public Works for an advisory opinion. You don't even necessarily need to contact your lawyer, but you can do that. You can talk to your school lawyer and work through the particulars, or just call them, and they'll give advisory opinions as to whether or not the contract that you're dealing with or is a public work project. Now, with respect to prevailing wage rate and the classification, it's important for you folks to know on contracts where you're letting out the work yourself, that you can, there's two forms that you need to submit to the Department of Labor, and you can get them online. And the first one is a PW-39 form. So if you're going to, that's how you can request prevailing wage rate for a project that you're going to do by yourself. You go to the Department of Labor website, and there's a form on there, and that will trigger them to send you the prevailing wage rate schedule. And if you don't know how to, the classification, is appropriate, again, they will give you the advisory opinion, or they will give you the information. That's what you would do at the outset, is use the PW-39 form. Now, when you go forward to and actually award the contract, there's a second form that you need to file, and that's the PW-16. Again, these are available on the Department of Labor website. And that form, you're telling the Department of Labor, okay, I've now awarded a contract to a contractor. It gives the Department of Labor the name and the address of the contractor, the date of the contract, or the date of the contract, and the monetary amount of the contract for the department's records. They will then go ahead and monitor that contract to make sure that that contractor is paying the prevailing wage to each of its employees with the appropriate benefits. All right. Now, again, dealing with, what wage rate or classification is appropriate. The Department of Labor is the one who sets these. They will look at the work, what type of work is being done, what's the job, what's the history, what's the recognition. Again, I'm just outlining these for you here. You don't need to concern yourself with them. The practical point is you want to simply request a prevailing wage rate, tell them what type of work you're doing. They will go ahead and give you that information, and then you can, you're obligated when you do the bid documents to include a reference or include the prevailing wage rate schedule in the bid documents, and then the contractor has to go ahead and work with the Department of Labor on the classification and make sure the payments are done. Then the contractor is obligated to submit to you certified statements or certified payrolls to have you pay them, and you need to maintain the certified payrolls in your office. Now, here's the part with the DOL compliance, where the contractors must submit the sworn affirm statements and the payroll records are true. The Labor Law 220 was amended a few years ago to require the school district's chief fiscal officer, who in most instances is the superintendent, but it rolls down to the business officials, to have a person designated under the contract to review certified payrolls for facial validity. Now, there's not been a case yet that's interpreted facial validity. What we've told our clients since the law was amended was that means you're obligated to spot check the certified payroll records to review them to see if they are paying the correct wage rate and schedule. So you would take it, compare the schedule to what, spot check certain employees and verify that that's being done. Then you have an obligation to maintain those records on your files. And the Department of Labor has been coming around and checking those on districts, and they'll bring enforcement proceedings, not against the district if someone's not being paid the right wage, but they will bring it against the contractor, and they will send to you a withholding notice. Typically, you will receive from the Department of Labor a certified document that says a certain contractor has failed to comply in paying an employee either the proper wages or the proper benefits, and therefore they're asking you to withhold from the contract balance, similar to like a mechanics lien on a project, funds from that contractor. If you ever receive one of those, you are obligated by law to comply with that and to withhold that dollar amount from the contractor unless and until you receive a notice from the Department of Labor indicating that it's okay to release that money. And I've had some of those last on projects for several years. We had one that I think the record we had was about 8 years. By the time the Department of Labor got through its enforcement action with the contractor, the school district had held this money for all that time. But the good news was the district did do it. We had told them to hold the money in compliance, and they did. I think the contractor had gone bankrupt for some period of time, so there was a stay which barred the enforcement action or something. But by the time the contractor got out, the Department of Labor did come in and collect, and the Department of Labor won its case and then came back with a court order saying to the school district, you're obligated now to turn that money over to us. And then the district did that. If you get one of the Department of Labor notices similar to a mechanics lien law, you would create a log and put a hold on the contractor's payment application. In the contract with the contractor, you need to make certain, especially when you're going to let one of these contracts out by yourself, if you're doing a small simple contract, that you have a line in there that the contractors must submit certified payrolls for your review, and that you would then maintain those on file. So if that's the completion of the Department of Labor compliance and documentation. If you have any questions on that, feel free to chime in. But if not, I'm going to move on to the next topic, which deals with the open meetings law in New York State. And as I said at the outset, the two areas that I want to cover with you would be the actual board meetings. School board meetings are open meetings. The school district is a public body as defined in the public officers law, where those meetings must be open to the public unless there are exceptions. And the one exception that I was going to talk about would be executive sessions. In central New York, there was a case recently involving the Jordan Elbridge School District, where that made a lot of newspaper coverage, where the board went into executive session. And the reason I'm covering this topic today is to try to have you each avoid any such misstep in the future. So executive sessions are sessions that is a portion of the public board meeting, and the Board of Education is authorized under the Public Officers Law to go into executive session and therefore not talk about certain topics in public, that they can go behind closed doors and talk about certain things. But there are very limited exceptions as to when that can be done. And the procedure that the board must follow if it wants to do that is they must actually hold a vote, and the total membership, it must be a majority of the total membership that agrees to go into an executive session. That vote must be taken in an open meeting, and it must be done pursuant to a motion. And then the key, and this is where the Jordan Elbridge District got in trouble, is that a motion to go into executive session must identify the general area or areas of topics that are going to be considered by the board when they go into executive session. And I go to, multiple board meetings in multiple different school districts, and it's astounding to me that sometimes a lot of boards do just what Jordan Elbridge did and just parrot the entire statute, what the Public Officers Law says, that they're going to go into executive session to discuss matters concerning litigation, the appointment of a particular person, to discuss real estate, and to discuss, the discipline of a certain person. And they'll just say all four things when I don't think the board really intends to talk about all of those topics. They really only intend to talk about one specific matter. And I think was the impetus of what Judge Greenwood, took exception to when he ruled against the Jordan Elbridge School District. And he ruled that you can't simply parrot the statute. You need to give particulars. So the exceptions, these are the enumerated purposes that a school board can use to go into an executive session. And the first is to discuss pending, proposed, or current litigation. If the board is about to be sued, has been sued, or is dealing with litigation strategy, that's a perfectly legitimate reason for going into executive session, and the board can talk about all of that in the executive session. But if the board doesn't have litigation going, and they're really going into an executive session to talk about collective bargaining, the board shouldn't parrot all of these reasons, including the current and pending litigation. And I've seen boards make that misstep a little bit. So the exceptions or the enumerated purposes are collective bargaining, to discuss those, The medical, financial, credit, or employment history of a particular person, corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension of that particular person or corporation. The list is continued on this slide, which says the preparation, grading, or administration of examinations, proposed acquisition, sale, release of real property. It makes sense. Board could go in to talk about how much it wants to pay or sell a portion of real property for, and they can do that behind closed doors. They can't, they wouldn't want to tip their hand in the public. Same with the collective bargaining negotiations. The rationales, it would undermine the board's position in public if they talked about all of those issues out in front. Information relating to current or future investigation or prosecution of criminal offense, which would, have an effect on the law enforcement. So any of those reasons are proper reasons for going into an executive session. But here's this slide is the Jordan Elbridge, the Zener versus the Jordan Elbridge School District case. And in this case, the Judge Greenwood was the judge, held that the board violated the open meetings law on 3 separate occasions by just merely reciting all of those statutory enumerated purposes and without setting forth more precise reasons for doing so. And the key here, or the kicker was that the judge not only held that they violated the open meetings law, but they actually awarded the petitioners attorney's fees in bringing their proceedings. So the district had to pay them. So the question is, what does Zener mean? What does that mean to you folks and your boards next time you're sitting around and they go into executive session and they go and perhaps talk about all of the enumerated purposes? You may want to then talk privately with your superintendent about, I sat through this webinar and, this lawyer told us, we ought to be careful about that in the future, and give a little more precision when we go into an executive session. And this is a balancing test because obviously the topic you're going into executive session to talk about is one that you need to do privately, so you don't want to go and announce the person's name that you're talking about, terminating or letting go or whatever. But what you can do is, so the question is, how precise do you need to be, or how precise does the reason need to be for going into the executive session, and how do you walk that line? What we think is, and what the Committee on Open Government has opined is that the board should identify a particular topic to be discussed, and really only that one, the one that you're going to use. So like I said, don't do the whole list, but if you're going to talk about the hiring of a particular person or a particular thing, just say that one reason at its outset, and then you don't need, that would minimize the speculation, as to what you're going behind closed door to do, and could obviate somebody bringing a challenge against your district to set aside your procedure if they've read the Jordan Elbridge case. I think most people know this, but again, if you're ever sitting in executive session and the board goes and wants to make a motion to take action, there are very limited exceptions as to when a school board is ever permitted to act in an executive session, and the one would be to bring charges against a tenured teacher. They must be voted on in executive session, but beyond that, really, executive session is simply to talk about these topics, get the board up to speed, and then a consensus, and then to go back into public session before the board ever acts on one of those topics. The next aspect with this is with executive session, who's entitled to go into the executive session is the board. The entire board shall go into the executive session, and they can invite who else they want to include in the executive session. But each member of the board shall be permitted in there unless they've got a conflict of interest under the general law, municipal law. So if they have an interest in the contract that they're about to vote on or to talk about, and they're going into executive session, if one of the board members actually owns the real estate that they're going in to talk about, that board member would be excluded. However, the balance of the board members would be legally permitted in there, and then the board has discretion as to whether it wants to invite you as the business official or our office as the attorneys to attend their executive session. The next aspect of the program that I want to talk about is the open meetings law and the FOIL requirement that came out in February regarding, it was February 2nd, I think, that school boards are obligated to make documents available to the extent practicable that they're going to be, if they're going to be considered at a Board of Education meeting, that you should post them on your website and have them available to the public. So Section 103 of the Public Officers Law contains two requirements. And the first is any document subject to disclosure under FOIL, as well as any resolution, law, rule, regulation, or policy that's going to be discussed at an open meeting must be made available to the extent practical prior to or at a meeting. The documents scheduled to be discussed must be posted on the website to the extent practical. That's the operative language with this new law, because it really comes down to a balancing test of when did the board know that they were going to talk about a specific document, when were they going to use it, and what we've been telling our clients is this is going to come down to a case-by-case decision or determination as to, did the board comply with FOIL and post the documents at the appropriate time. I mean, if this item's been on the agenda for several weeks and you knew that you were going to talk or vote on a particular contract, those factors would tend to lend itself to say that that contract should be posted on the district's website in advance of the meeting. But if something just came up in the day or two prior to the board meeting and items added to the agenda, those facts would lead itself to say that, well, that wasn't practicable. You didn't have time to pull the documents together and get them included or posted to the district's website. Hang on, the slide is stuck for a minute. There. Okay, so the buzzword, to the extent practicable, like I said, it's reasonable and practicable evaluation of the facts and circumstances. And in each case, you're going to have to look at them and make a decision and what your policies and practices are. The key that, again, what we've been saying to our clients is you don't want to be the test case, or you don't want to be the expose for the local newspaper to come in and say, this law is in place and it requires the public posting, and the district has not been compliant. So to the extent you can make the documents available, why not go ahead and do that and have a practice set up to have them scanned and posted and have them available. Now, so there was language originally included in the bill that would say that you had to post it at least 24 hours prior to the meeting, and that was rejected, and that was taken out. So there is no requirement to that. It is really just to the extent practicable that you would have to go ahead and make the documents available. And if you make them available, the morning of a meeting, again, as far as when you go ahead and make them available and whether or not you'll be criticized for that, I think depends on a case-by-case determination as to when they were. I mean, if you make the document available the morning of the board meeting, but you knew you were going to talk about it for 3 weeks and you had the documents already, then you could be held to run afoul of this. Conversely, if you're still negotiating the contract right up until the day of the meeting and you don't post it, I think you're going to be fine. So that's, in essence, that's the issue with respect to the new posting requirements. Oh, the key, the practical thing is that I didn't say before with the public posting is all of this new posting law and making documents available prior to the board meeting. Please don't forget what that means is you still go through the original initial analysis as to whether or not a document is subject to FOIL or not. So simply because you're going to talk about something at a board meeting, you would still go through the litmus test or the analysis of, is this an intra-agency document where it's not subject to FOIL, where there are exceptions to the public release of the document. And if so, then obviously you don't need to post a document like that. That's just simply because it's going to be talked about at the board meeting, okay? Now, this Hamilton versus Board of Education, the Jordan Elbridge School District, this is another one of the Freedom of Information lawsuits that was brought against Jordan Elbridge. And what this dealt with was there was an amendment or a termination of an employment agreement between the district and its former superintendent of schools. And the contract dealt with the employment and the post-termination employment benefits of that superintendent. And the petitioner alleged that the district failed to acknowledge a FOIL request and then denied the petitioner's appeal to see this document. And in the proceeding, the petitioner sought to compel the district to provide the documentation and requested attorney's fees as well. And the district refused. And, the general rule, as we said before, is FOIL is based on a presumption of access, and all records of an agency are available except to the extent that those records or portions fall within one or more of the grounds for the denial under Public Officers Law, Section 87. And FOIL will be liberally construed, and any exemptions, so if you're trying to withhold documents, any of the exemptions that you're trying to enforce will be narrowly interpreted as opposed to liberally construing whether a document's available or not. So in this case, Jordan Elbridge tried to withhold the records, and they said this is going to be an unwarranted invasion of personal privacy into the superintendent's or the former superintendent's life, because it's going to talk about these post termination or post leaving of the district's benefits. And the court came back and said no, that's simply not the case. That contracts between school administrators and the board must be disclosed, and the court said, look, you can't deny a request simply because you think it's an unwarranted invasion of privacy. So be mindful of that, I guess, in the future. And the court also noted in the Hamilton case that simply having a confidentiality agreement. One of the things the district argued in the case is, look, we have a confidentiality agreement in the contract, so they tried to say, well, we can't disclose this because we agreed to not disclose this information publicly with the superintendent or the former superintendent when we signed the contract. And the court said, that doesn't bother me because that's a violation of the law. You're not allowed to do that, and I'm not bound by that provision. And so he ordered them to disclose the documentation and ordered them to pay the attorney's fees as well as a result of that decision. So that's all dealing with the Jordan Elbridge, a Hamilton case where they tried to withhold a settlement agreement with a former superintendent of schools on the basis that it was an unwarranted invasion of privacy and that there was a confidentiality provision in the contract itself that barred the release of the information. And the court said no on both accounts and then ended up awarding the petitioner the attorney's fees on that case. Now, the last case that goes along with this unwarranted invasion of privacy is the teacher data reports. It's this Mulgrew case from the Board of Education out of New York City, where the first department affirmed the lower court ruling that teacher data reports in the city of New York, where it listed the teachers' names and the proficiency of their performance in their job duties, were interagency materials under the public officer laws that were subject to disclosure under FOIL as statistical and factual tabulations of data. Although some of the data may have been an estimate or recommendation, it did convert into an opinion that was subject to FOIL, and it wasn't subject to the opinion exemption under the FOIL. So in this case, the petitioner sought an order directing the city school district of the City of New York to redact and keep confidential the names of any teachers that appear in any teacher data reports that were released to the public. And this was all back in 2007 and 8 school year. The Department of Education for the City of New York launched its pilot program, which obviously you folks have been reading about with what's coming along with the rest of the teachers and whether or not they're going to be obligated to show the teacher efficiency scores. This is the predecessor case that we're talking about. So the comparison in the Mulgrew case was whether this data, the value-added data that showed the test scores for the teachers and the children, would be a basis to rate the teachers. And so from August 2010 and continuing through October 2010, the press interveners made 9 separate FOIL requests requesting the teacher data reports, including disclosure of the teachers' names and the actual grades, that the corresponding numbers for each of the teachers. And the Department of Education responded that those requests, and it complied. The Department of Education for the City of New York thought they were complying and said, look, we'll give you the numbers and the scores for each of the teachers, but we're not going to give you the names because that's an unwarranted invasion of privacy. And the United Federation of Teachers commenced an Article 78 proceeding, and in the Article 78 proceeding, the public officers law was held to say that no, in fact, these teachers' names and the scores are subject to disclosure under FOIL, and they're not allowed to be redacted. And this is the First Department Appellate Division affirmed that holding and required the disclosure. So whether or not teachers' grades or performance will be required to be disclosed by other school districts, this case seems to indicate that if, in fact, that those scores and the teachers' efficiencies rating, unless there's some change in the law, would, in fact, be subject to a FOIL request by teachers. So, or I mean by parents. So that's the topics that I had prepared to talk about today for you to cover the Wicks Law, the Open Meetings Law, and the basic bidding requirements. I don't know if anyone has questions. We have some more time designated to the program today. I'd be happy to field those. If not, that concludes the remarks that I'd prepared to review with you today.
If anyone has a question for Joe, go ahead and either type it into the chat pane or hit 7# on your phone, and then we'll put you right through. I'll give you a couple seconds to go ahead and do that. Joe, we have a question in the chat from Rob Meza.
Okay.
Joe, if the board is voting on the superintendent's contract, do I have to post that on the website?
Does he have to post the contract on the website? Is that the question?
Yes. Rob, if you want to hit 7# on your phone, I'll put you right through to Joe if you'd like to ask the question yourself.
Sure, Rob.
Go ahead, Rob.
Hey, Joe, how you doing?
Good, Rob. How are you?
Good. I just, what's supposed to be on the website now, everything that gets really foilable.
Right.
And we're going to be, the board's going to be approving the superintendent's contract. So, do I have to post that full document on there? It really is, a public document.
Are they approving an amendment or the entire?
No, they're approving the entire contract.
Okay.
It's just renewing.
Okay. Unless there's another exception to FOIL for that document that would apply, I think under the new requirements that would be the case, that you would have to post that.
Okay.
And I'll think longer and hard about whether or not there's anything in there. But I tend to believe that is a public document.
Yeah, me too. But I figured I'd ask you.
Yeah. No, I think that's.
Great.
I think that is one of the topics. Now, whether, because if somebody had just foiled that document, I'm just going through the analysis in my head.
Right.
You would have to provide that.
Right.
So, I think you can post it on the website. And the law is silent. I think that brings up a good point as to how long do you need to leave it up there is another matter. I don't think you have to leave it up in perpetuity.
Right.
I think it's that the board is going to talk about the contract, and therefore you post it so somebody could read it and then ask questions about it if they wanted to.
Yeah, the day after the board meeting, we went take.
You could take it back down. Right.
Okay.
Right. That's a good practical.
Appreciate it, sir.
Sure.
Thanks.
Sure.
All right. Have a good weekend.
Thank you.
Take care.
Bye.
And we'll give anyone else who has a question another couple seconds to hit 7# so you can ask Joe a question. Okay, we have no more questions. Joe, thank you very much for your presentation today.
Thank you. All right. Have a great day.
And everyone will have a great weekend.
All right. Thank you.
Thank you. Bye-bye.
Bye-bye.